Today, we are pleased to offer our second webinar in the Academic Integrity series titled FOIP Training for Academic Integrity, presented by Jennifer Sinclair, the FOIP Coordinator at Legal Services. And with us today also is Amanda Bevins, a FOIP Advisor at Legal Services. Before we begin, I would like to take this opportunity to acknowledge the traditional territories of the people of the Treaty 7 region of Southern Alberta, which includes the Blackfoot Confederacy, comprising the Siksika, Pagani, and Kainai First Nations, as well as the Tsuut'ina First Nation and the Stoney Nakoda, including the Chiniki, Bearspaw, and Wesley First Nations. The city of Calgary is also home to Métis Nation of Alberta Region 3. As I read the land acknowledgement, I always like to think about how privileged we are to live in this land, that we share, play, and work with our fellow people. Welcome, Jennifer and Amanda.
Thank you, Lorelei and Cheryl. Thank you, everybody, for being here today. Today, we're going to look at the intersection of FOIP and academic integrity. As Cheryl said, I am the FOIP coordinator for the university. I am charged with the day-to-day administration of the FOIP Act at the University of Calgary. The presentation has been made very generalized because I understand that there are individuals from many other institutions. So we've made it very generalized to a little bit of what we do at U of C, but more or less best practices, privacy, academic integrity. As Lorelei said, I have my colleague Amanda Bevins with me as well today. Amanda's also a FOIP advisor in the FOIP office and legal services here at the university, and also available to answer any questions after. If you're not comfortable speaking during the session, please reach out to both myself or Amanda. So let's get started. Little cliff notes by the end of the session. What we're looking to do, understand the impact on that FOIP Act on those university policies and procedures. That would be specifically to the University of Calgary. And then as a broader principle, understand FOIP and the Freedom of Information Act, privacy as a whole, as it applies to academic integrity issues. We've broadly divided the session up into two parts. The first part is going to focus on FOIP, which is the Alberta privacy legislation. What FOIP is, what is a record, why we, basically what the purpose is, what FOIP allows, why do we need that privacy legislation? And the second half of the presentation, we'll have a little pause for a Q&A session. If anything generates from the first part, we have a little interactive moment. And then the second part is going to focus more specifically on those general principles when dealing with student misconduct, student non-academic misconduct, and where those lines are and what we would recommend, perception of bias, things. And then we'll also have a second opportunity to do a Q&A session again at the end. As I said, if you're not comfortable participating in the Q&A session at any point, that is absolutely fine. There's no need. You can both reach out to myself or Amanda after the session, and we can provide you a one-on-one discussion. So you'll hear me mention a couple of times the Freedom of Information and Protection of Privacy Act. In its shortest, I will refer to it as FOIP, as its acronym. I know there's individuals outside of the university. If you're located in BC, Ontario, or Saskatchewan, your institution will have a very similar legislation to FOIP. In terms of how similar, we have the exact same wording of the acts. It'll just change a little bit of the section numbers. So BC, Ontario, Saskatchewan, very similar. Majority of what I say is going to apply. It's strictly written into your act. The other provinces, you will switch between PIPEDA, which is your Federal Privacy Act, the Personal Information Protection and Electronic Disclosures Act. That's quite the mouthful. And any other relevant legislation in your province. So bearing that in mind, Alberta's FOIP, what is it? It's a provincial legislation that applies to post-secondaries. It originally came into effect in 1995. At that point, it was very narrow, the scope of the act. It then expanded in 1999 to include post-secondary institutions. The former coordinator at the University of Calgary was very integral to that process, and she actually helped write that. So we had great input into what the act looks like. As employees of a publicly funded body here at University of Calgary, we must comply with the FOIP requirements. It sets out the parameters for the collection, use, and disclosure of all personal information. It also governs how we process access to information requests. So at its most basic tenet, what is an access to information request? It's when an individual comes to my office and says, the University of Calgary has collected or used this information about me. I want to know what it is, and I want access to those records. That is very important in terms of what we're talking about today, academic integrity, because we do get quite a lot of requests where individuals who are involved in academic integrity or associated individuals, parents, faculty members, etc., want to know what's happening in those cases. So that is absolutely dealt with by my office under the FOIP Act. At its very basic level, I'm not going to go through these one by one, but what's the purpose of FOIP? As I said, to allow any person the right of access to those records in the control or the custody of the university. If an individual submits a FOIP request to my office, they don't need to be a Canadian citizen. They don't need to prove their identity. They don't need to tell me why they're looking for it. As you can imagine, quite often that leads to a needle in a haystack type approach when I'm trying to determine what an individual wants a record for or what they might be searching for, but I'm not able to ask them. The other one that we look at a lot of the time is to allow individuals the right to an independent review. Particularly in the case of academic integrity, sometimes individuals have gone through that separate process. They have felt that there is something happening behind the scenes possibly, or something that they just want more information on. So they then come through their FOIP process to gather those background notes, those background materials, which is very important, and we'll cover in the second portion of the presentation of how we make sure that we're aligning ourselves and what the proper best practices are for those records to ensure that things are being captured appropriately, things are being recorded appropriately. A couple times throughout the presentation, just one distinction is that you will hear me say custody and or control. The Act lays out both of them. It is not a both have to apply, it's an either and or. So in terms of custody, it's if the university is physically holding a record or physically retaining the record. Think active records in an employee's filing cabinet, in a central filing system in HR, the Academic Integrity Office, inactive records in a storage facility off campus, any electronic records on your employee computer at work or stored in an electronic communication system. That is what is meant by custody. However, the Act also applies to a record under the control of the university, where the university has the authority to manage that record. So by manage, I mean restricting, regulating, administering the record. The university can decide when the record's destroyed, when it must be produced, etc. Even if it was created or stored on a personal device, such as a smartphone, a notepad, an iPad, if it was created by an employee of the university for a work-related purpose, it is subject to FOIP. So that's a little bit of a note of caution if you switch between multiple devices, university issued versus personal issued devices. If you are using that device for a work-related purpose and you're communicating on work-related matters, those records are subject to FOIP, even if they're not on our own devices. With that, I always caution to write with access in mind. Students have filed those FOIP requests in the past, as I said. FOIP also, one of the big parameters is it allows us to collect personal information only that is directly necessary for an operating program. It could also include administrative investigation if it leads to a sanction or a penalty. We can use that personal information we've collected for the purposes of the investigation, but you can't repurpose that personal information for any other reason. That's one of those non-highlighted 5 purposes of FOIP, but just to give you an idea of where or why we're collecting that information. So you hear me say a record. What's a record? In its broadest form, I'm not going to read this out, but more or less it's everything. FOIP applies regardless of the creation date, the format, or the status of a record. In practice, it's mostly emails. I would highlight a verbal discussion is not a record. We'll go into this a little bit later on the best practices side, but I can say sometimes having a phone call or a face-to-face is the most appropriate form of communication. especially in situations where you feel like you cannot adequately explain during a email or the nuance doesn't come across. That is not part of the FOIP. That is not FOIPable, for what I like to say. But if you create and keep notes of that conversation, that is a record and that is subject to FOIP. So this always gets a little bit of a giggle. What is subject to FOIP? I've told you what isn't subject to FOIP, which is those conversations, those communications, anything recorded, anything recorded. Email, text messaging, voicemail, posted notes, photographs, docs in a SharePoint, something in the cloud, just examples of things that are subject to FOIP. Emails, notes that you create in the course of an allegation, investigation, or an appeal are also records under FOIP. Again, that verbal discussion, not a record, might be the most appropriate way to have those conversations when you think that they're nuanced or really not going to be appropriately conveyed by email. One that always gets a little giggle is it does not apply to questions on an exam or a test. I can tell you that we get this at least a few times a semester from individual students who say, I am taking Professor X's psychology course. We have a midterm in 3 weeks. I'd like to go through the FOIP process and I'd like to request the exam. I can assure you that those are never released. It's not something we entertain under the Act. It's specifically carved out of the Act because it was understood that that's something that post-secondaries deal with, and we would never provide research or teaching materials or preemptively or post-emptively provide any questions on an exam or a test that was upcoming or in the past. So in our FOIP Act, we have a definition of recorded information or personal information. As I said, those acts in BC, Saskatchewan, Ontario, very, very similarly written. I think PIPEDA, I don't know their formal definition. The PIPEDA, the Access to Information Act, both federal, as well as PIPA, which is the Personal Information Protection Act in Alberta for private organizations. We all more or less follow the same principle. What's personal information? It's something that could be used to identify an individual. So name, address, email, phone. Those are considered, I would consider first level personal information. That's not to say we can absolutely go ahead and collect those willy-nilly or without regard, but that's what I consider a low risk type of personal information. The reason I consider that is your name, your business email, your office phone number, your office location. The majority of time that's contained in a LinkedIn, that's contained in some sort of social media, that's also contained on a business card. So there are other ways that individuals can gain access to that information. What I consider the more sensitive information, that social insurance number, biometric information, health information, educational information. We need to treat it all in the same manner. However, my senses are a little enhanced when I'm dealing with that level of information, because the damage you can imagine if somebody discloses something to a hearing board and then that became public information, it may not be fit for public consumption or something that they would like shared broadly if it's something that they're struggling with or something of that sensitive nature. A little caveat in the Act that we always run into that's interesting is, so personal information. It's everything you can imagine, that top, as I said, very generic, name, address, etc. Someone, your opinion is your personal information, unless your opinion is about somebody else, in which case it's their personal information. So you can imagine how that works in an academic integrity situation. My personal information is my own. Lorelai's personal information is her own. Lorelai's opinion is, and I'm using you, Lorelai, because you're on the screen in front of me, and Lorelai's personal information is her own. However, if Lorelai has an opinion, she owns that opinion, it's her personal information. I can't disclose that personal information unless she consents to it. However, if that personal information is about me, the decision of whether to disclose it no longer lies with Lorelai. It's my personal information. So as I said, we run into this a lot with academic integrity, where we need to be cautious of how things are written or best practices are written, of whether you are giving a stated fact or a factual account, or whether you are expressing your opinion. Because although that personal information belongs to the individual, the information's out. Again, the records in the custody or control of the university, and it's my office that makes that determination of whether it's going to be released. And we have run into situations before where individuals outside of an academic integrity process have made comments of coworkers, fellow academics, etc., where they've said, absolutely not, this is wholly embarrassing. I really can't have this get out. But unfortunately, under the FOIP Act, it's not their decision if it's about another individual. The overriding principle, if you remember anything, is that the personal information belongs to you, the individual, and you have that right to access it. With that being said, a key caveat is, as an employee, you don't have those same privacy rights. As an employee, as an academic, your salary range, the benefits you're entitled to, anything you create in the course of your work may conceivably be released. That's not me saying that we're absolutely going to go ahead and say, here's a little portfolio on this individual, but there are other legislation. So here in Alberta, we have the sunshine list, the salary disclosure list, the threshold of 125,000. There is nothing that my office can preemptively do to override that. That is a piece of legislation that is paramount to the FOIP Act. So we must comply with that. If someone was to come to me and say, Jennifer's the FOIP coordinator, what is Jennifer's salary range? I would be required to produce it. I do not have to produce my exact salary, but I do have to produce my range. I do have to produce that I am a MAPS employee, and these are my entitlements as a benefits, those type of information, but I don't have to specifically say, here's what she has elected in her benefit statement type. Exceptions to disclosure. The FOIP Act, the way I've described it, you would think that it was hundreds and hundreds of pages long. It is 90 pages in its entirety, and it has not been updated since the 1999. So you can imagine it does not account for cloud storage, court decisions, any of the changes that have occurred since that time. But with that being said, we rely on precedents, we rely on decisions of the court to determine what we are or are not going to disclose. These are the most common exceptions to disclosure of information we see. I will say that FOIP is very, very gray. I really wish it was black and white sometimes. It is very, very gray. All decisions are driven by context. So in terms of disclosure harmful to personal privacy, that would be information I would look at where a student has provided information to a hearing board. Another student may be seeking that information. And the student who was the subject of the original request says, you know what, I'm not comfortable, I'm not consenting to that. 99% of the time, I can say my office absolutely respects that, and we would not disclose it. That information, if the student did not consent, we would say absolutely not. Even if the student consented, we may very well say, no, you know what, this is personal information of another individual, you have no right to it. Disclosure harmful to individual or public safety, a very, very high threshold to meet. There have been cases in the academic integrity world or that student non-academic academic misconduct, as well as other policies at the university, where we have disclosed that type of information. But as I said, it's a very, very high threshold. And the individuals who would receive that information under that section would be, I am talking executive leadership team, Calgary Police, the very, very high level individuals. That's not something that would be released. I can think of, it would need to be a very, very small use case. The context would need to be very onerous to release that to an instructor or a department head or anybody at those levels. Confidential information. That more or less covers the other ones in the broadest sense. What we look for is whether that information was supplied explicitly or implicitly in confidence. And that expectation the information will be kept confidential, it must be objectively reasonable. So we can't just say, yes, this was held in confidence, or yes, we've determined that this was confidential. We look at a few factors to determine whether a party has objectively that reasonable expectation that it was supplied in confidence. So we can argue it's been supplied in confidence. So we look at whether it was communicated to the public body on the basis that it was confidential and to be kept confidential. How has it been treated when it's in the custody or control of the university? Was it treated in a manner that indicates a concern for its protection from disclosure? So was there a very small distribution list? Did the distribution list have a confidential flag on it? Was it marked confidential in the subject line? Was it marked high priority? Was it forwarded? Did it contain a lot of unnecessary recipients? We look at that as a whole to determine whether that record was confidential. In addition, was it disclosed anywhere else? Or was it available to in any other sources to which the public has access? And why was it prepared? There have been more and more decisions in the academic integrity world that we've looked at where that confidentiality provision, we've really looked at it hard of. How was this conveyed? Did this go strictly to the board? Did this go through, or did the student send it to, in some cases, the entire mass mailman list? Or did it go to specific individuals? When the board was discussing it, was it in a closed discussion of the board, or was it in a much broader sense? So those are all things we look at while determining whether the information can be disclosed. I will highlight that a draft does not constitute an exception to disclosure. If you have written it down, if it is recorded, it is absolutely accessible under FOIP, whether a final version has been completed or not. We'll cover that a little bit more in the back section, dealing specifically with record management and best practices. But I like to say, unless you have drastically changed courses between version 1 and version 8, there's no need for version 1 if version 8 is the latest working draft. And embarrassment does not constitute an exception to disclosure. I know there's some individuals who really, really wished at some points that embarrassment was an exception. It's not. Again, we'll cover it a little bit later, but general principle here is, if you would not be comfortable saying it on the front page of a newspaper or in a very public forum, think twice before writing it down or conveying that. So I bet lots of people have questions on this because this is one of the most popular questions we get in the FOIP office. What can I disclose? This list, as I said, is very specific to University of Calgary. If you're from outside of the University of Calgary, you may want to look at your own policies and procedures to see if there are built-in information sharing clauses within different policies and procedures. For us at the university, this is built into the privacy policy. I'll have a link later on, but it's built directly into our privacy policy. And it says, here's what I can disclose without needing to go to the FOIP office, without needing to that level. So dates of registration at the university, faculty department, degree diploma awarded, convocation dates, absolutely something that we consider public information. We seem to get more of these inquiries right around election times when individuals represent they're from different institutions. Our alumni office, our HR office, my own office gets a lot of these inquiries saying, this individual represents that they're from the University of Calgary. Can you confirm? That is the level of confirmation we do. We give no information beyond that because it's considered personal information. On the same token, attendance at participation of a public event. So we're talking about graduation, McMahon Stadium event, a University of Calgary ribbon cutting, things like that. If it's in the public domain, the media has already picked it up. We know that a certain dignitary or individual is attending the university. We'll also disclose that information without needing to go down that consent route or speaking to the individual the information is about. Anything else must be carefully considered. If you're not sure, ask the FOIP office. My team is here to help. We see, as I said, we see dozens and dozens of these. We're absolutely here to help. You may also receive requests for student information. So off the top of my head, a student, a course instructor, a student advisor, the registrar. We're seeing a larger uptick for whatever reason of the student's parent calling to check on the student's progress. How you respond to those types of requests and what information they're entitled to is going to differ depending on the context as well as the use case. So I say you can absolutely send it to my office. The registrar's office might be apt to release more information than another department if they have parental consent. There's parental consent forms built in. If the individual's a mature minor, very, very rare. We treat everyone at the university, if you're a student, unless you are a 13-year-old coming in and we have a special situation for you, we treat you as an adult. You are a mature minor in our mind. Whether you're 17 before the start of the year or you're 18, you're a mature minor. But all those individuals, it's really going to depend on the use case. And that's why, again, I reiterate, feel free to send it to my office. If you're not sure, I would rather get the same question 100 times and be able to say to individuals, yes, you're good, to just catch that one time that we should not be releasing that information. Employee information. So as an employee of the University of Calgary, what can be disclosed? This is the information about you that can be disclosed without your consent. So your status, as I said, business contact information, your job title, your range, your relevant educational qualifications, if you're convocating, a list of things that are already in the public domain. So if your CV is publicly posted on the University of Calgary website and an individual calls in and says, do you happen to know if this person actually co-wrote this article? And we see your CV posted there, we might do a quick verification and say, yes, actually, or you could go to this website and look for yourself. Anything beyond this is not disclosed except in exceptional circumstances. I could say those situations are very, very rare. And you would be getting a call from my office where we would say, you've been identified in a FOIP request, or here's what we're looking to release about you. You're not a formal third party in terms of the act, but we would consult with you and say, we're leaning towards no, unless you're consenting to us doing this, or there's a really good reason you'd like us to release this information, then we're just going to deny to release this information. So this is our first stopping point. I will stop and say, does anybody have a particular instance in which they felt information was overshared or unavailable that we can elaborate on? Again, if you're not comfortable speaking in this forum, that's absolutely okay. We can continue on, or you can reach out to myself or Amanda after the fact, and we could provide a little bit of context why that might have occurred. And Amanda, if you also have any questions come into the chat.
No questions in the chat at this time.
Have any questions any hands popped up? I can't see from my end.
No questions, no comments. Oh, we have a hand now.
Oh, there we go.
Go ahead, Fabiola. Just unmute yourself there.
Sorry, I mean, you'd think I'd get the hang of this by now. Sorry about that. Yeah, so thanks very much, Jennifer. I'm still a little bit unclear on the parent phone call. Just because as a director of a program, I tend to receive those. My response in the past has been that we can't disclose information of an adult learner and that they need to talk to their son, daughter, whoever, and to figure that out. And then I have to have written permission. Mm-hmm. So is that correct? Like, I was a little unclear with what the actual rules are.
That is absolutely correct. The procedure you're following is absolutely the process I want in place. There are situations where the registrar's office, they have processes in place and they have forms on their website where if a student did want to give that consent to their parent to call in and check on different things, there's a form to be filled out which gives access to that information to a third party.
Okay, so I can redirect them to the registrar's office for that?
Yes, okay. There's a form built in that says, I am the student, I'm giving authorization to this individual to know about my progress at the University of Calgary for these particular reasons.
Okay.
Or this level of information.
Thanks. Yeah, I just wanted to be really clear on that. Thank you.
I can understand you probably get dozens of those. I
No
will
other
continue.
questions. Yeah, you can go ahead.
Perfect. Thank you. So we've covered off the first half of FOIP. We've covered off what FOIP is. Why create a record then? If we know a record is FOIPable, we know a record can be requested at any time. We know about that access. Why create a record? Record creation is sometimes something we do self-consciously. So minutes of a meeting that are intended for public consumption or deliberately a note to file to assist with memory. Most often, it's a natural byproduct of work-related activities. We create a record because we have a duty to document. We have a duty to fulfill legal requirements. So contracts, financial records, business decisions to document what happens. We should not avoid creating a record that will be needed by the university simply to avoid having to procure that record under FOIP. With that being said, FOIP does not impose an obligation to create a record. So it's a little bit of a catch-22. Why do we create it? Well, those are the reasons we create it. However, we're not required to create the record. So what I always like to say is, does this record need to be created? If I was to leave the university tomorrow, if I was to leave any job tomorrow, would this record be useful to someone, or would I be the only individual who understood what this record was about? Am I fulfilling a legal obligation? Am I hitting on one of these 4 bullet points of why I'm creating that record? If I don't think that I'm fulfilling any of those reasons, I might be the only one to understand the record, or there's not a necessity. There was no intention to a closed meeting, one set of formal notes. Do I really need to create it? That's entirely up to the individual to decide. Creating records. Always create those records with that access in mind, not only from a FOIP perspective, but as I said, there's other processes at the university where you may be required to produce those records. Specific, I would say, to those academic processes, record objective evidence of wrongdoing, that poor behavior, those problems, those issues. This goes back to what I was saying a little bit earlier about personal information. Does the personal information belong to the person who wrote it? Does the personal information belong to the individual it's about? Well, one way you can ensure not that the record won't be disclosed, but you can ensure that we're following those parameters is record objective evidence. Assume someone will ask for access to that information you've recorded. And then using those confidential legal advice tags, the high priority tags, use them sparingly. It signals the intention of the record creator with respect to who should have access to that record. It makes that confidentiality expectation explicit to those who have access to the document. It does not guarantee an exception to access, but it really helps us flag it under FOIP of if we need to look at that document a little more closely, if there is context around that, if there's a specific reason why you would have used that flag. It really allows us to determine whether that record was provided implicitly or explicitly in confidence. Because how a record is treated may change from one point in time to another point in time. So example I commonly use is documentation in a closed session of the board. So this could be the Board of Governors, this could be a hearing board. It may be confidential at the time the information was provided to the board, but in the public domain at the time we received the access request. Just because a record was excluded from disclosure at one point does not mean that it's always going to be excluded from disclosure. Which is another reason why we always need to record that objective evidence. We need to write as if somebody will ask for access because it's possible it will change. Also, advice of the dean. I can think of situations where you may have dealt with a situation, you have forwarded it on to the dean. At that particular time when there's an investigation ongoing, a student may be enrolled in your class, that would be confidential. However, 5 or 6 years down the road, an investigation's been completed, it's gone through the process. Has the harm changed? I would argue, yes, the harm has changed between when it was originally conveyed to the dean versus when it's being conveyed at this point. If you remember anything from this presentation, please, this slide right here, do not record unsubstantiated subjective evaluations. Humor does not always translate well. It may seem unprofessional. Examples we've had from other FOIP requests, I can think of off the top of my head. Why do I get all the cheaters? Here we go again. And diagnoses on mental illnesses that individuals feel that other individuals hold. If you do not have the expertise, you do not have that piece of paper, it is not your side, it is not your field in which you are not an expert in and qualified to make those evaluations, please do not make those evaluations. There have been situations, as I said, in FOIP requests where individuals have requested those records after the fact, and these comments have been caught in those records. And again, embarrassment, not an exception to disclosure. On the same note, sarcastic, derogatory, anything that would discredit the objectivity of the record. On a little less serious note, I can think of a FOIP request from a few years ago at a different institution where a counseling type service was seeing different individuals from within my former employer. The character who was seeing them all decided to name them after characters in movies. To that individual, it may have been a little bit humorous, but when working through those records later, 5 years later, myself reading them, it was Winnie the Pooh came to see me today, followed up by Batman. Oh, I can say there may have been harm associated with that, but it was more so confusing of, I have no idea who you're talking about, because the context 5 years later, it makes absolutely no sense. And it was quite silly at that point. So if that's what you're not recording, what should you record? Be factual, be specific. Thinking of an incident report to the dean, A happened and then B happened, C happened, D happened, here's what I did. Use those confidential flags, use those legal advice flags. Figure out a record retention, figure out whether you're keeping it in paper or electronic storage. You don't need to keep both in the same way you don't need to keep those drafts. As an academic under the University of Calgary policies, once you hand those records to the dean then has carriage of those records. You can look at our master archival records retention schedule, which I'll go into a little bit, and what that is, but it designates an office of primary responsibility. You as an individual are not the office of primary responsibility. It's a greater duty. It's a unit, it's a department, it's a faculty. Once you've handed those records over, the carriage of those documents goes to another individual or another department as a whole, the dean's office. Once it proceeds to a hearing through the student academic or non-academic process, it then transfers from the individual faculty to the hearing board. They now have primary responsibility for those documents. So you don't need to keep copies of everything you're sending. It might be a good idea for a little bit of time. But after that, I would say, a semester or so, you can, once you know that it's been resolved, you can go ahead and get rid of all those records. Respect privacy rights. That's something I feel is one of those basic principles that sometimes we move a little bit away from. That basic FOIP principle is to collect, use, disclose as little as possible. You only need the information necessary for the job to be completed. That student has the right to privacy, and it's not forfeited because of an academic misconduct investigation. It's not forfeited because we feel that an investigation may be warranted. So we need to proceed on the basis of innocence and that right to privacy and maintain that. Switching gears a little bit here. We've had a few cases. Perception of bias. It's not to say that individuals are biased. It's that perception of bias. Be aware when posting on your own social media sites. Be it true or false, the comments posted on your personal time may contribute to the perception of bias. In terms of best practices, keep your personal social media free of work-related material. We've had files in recent years where that social media postings in the context of one's personal life have crept into the university space. And there's definitely been an overlap. One of the main questions we get is academic integrity issue arising in the middle of a course. What do I do? Should this have an effect on future assignments and submissions? Our recommendation always trust the process and continue grading. The instructor will know the student's grade, which reveals the outcome of the investigation. Once the instructor has handed that investigation, or they've said to the dean, I think this person may warrant an investigation, the instructor does not receive any more information than that. A TA may need to know a limited amount of info so they don't change the grade again. So this is very similar in line to the protected disclosure process we have in place. But as an instructor, it's to continue grading, trust that it's at the dean level, and they will pursue it, or the department head, in whatever the appropriate manner is. That also contributes to moving away from that perception of bias. We've touched briefly on this. Definitely becoming more of an issue with the hybrid situation, but some formats are just inherently insecure. So voicemail, instant messaging, a lot of MS Teams, Zoom. MS Teams and Zoom are meant to assist us in our work. They are not meant to be a formal system by which we communicate and make business decisions. They are never intended to do that. To that end, at the university, you may have seen communications. Zoom recordings are deleted. They are now periodically deleted just for space. My team is going through the exact same process right now for MS Teams chats. This won't be in official channels, but those MS Teams chats between individuals are going to start to be deleted on a rolling basis. So if you have anything in those chats, I would highly recommend get them out. They were never intended to make formal decisions. They were never intended to be the record of the event happening. And sometimes reiterating, communicating in person, it may be the most appropriate option. If it's sensitive, if it's detailed documentation, if really you don't need to make meeting minutes of that, but you just need to have a quick touch base with the dean, or you need to have just a quick touch base with another individual, sometimes that phone really is the best way to go about it, or an MS Team saying, can we talk about a student? Please don't put names, please don't put identifiers, but setting up the meetings, that is what those communication boards were intended for. Because all still accessible under FOIP, MS Teams, Zoom, text messaging, any type of electronic transmission, it's inherently insecure and it's all accessible under FOIP. We're almost at the end here. I'll tell you, managing records. I've talked about why we create records. We've talked about why we should not create records. Managing records. I would always say, if you are working on a committee, if there's a hearing board, if you are a member of that hearing board, there should be a very clear statement or a very clear idea of records management. Who is responsible for that records management? Are all individuals going to maintain their own records? I would highly recommend against this. Who is going to be responsible for the records? Best practices, the chair designates themselves as the records management holder. Everybody keeps their own individual records, maybe during a hearing, their scribbles, etc. At the end, all those records are provided to the chair, and they're deleted from the individual's own email, share drive, folders, notebooks, drafts. The chair is then responsible for weeding out all those duplicates. And the chair assembles a one singular record that serves as the hearing record of the proceeding. Everything else may be considered transitory, may be considered a duplicate, and then the chair, as go back to that Office of Primary Responsibility under our University of Calgary specific retention rules. When the FOIP office comes looking, or when anybody comes looking for that record, that is the formal record of the proceeding for our legal processes or anything of that nature. This eliminates that duplicate material being kept in multiple sites across the university. So if the chair is designated for managing that formal record, what can you do as an individual to assist in that? I won't go into much detail on MARS because it is university specific, but it's the Master Archival Records Retention Schedule. What that does at the University of Calgary, our privacy legislation says we must have a reason, or we must have a document in place that sets out the life cycle for records. When records are created, deleted, and why they're deleted. to ensure that we're not destroying records when we just don't want to be subject to a FOIP request. How can you assist that? You can remove those transitory records regularly. Transitory records under that records retention schedule includes, we're having a potluck this Friday. Can you bring so-and-so? Those type of records that you may use MS Teams for, but you may also send an email that says, hi, so-and-so, can we go ahead and chat on an ongoing issue? Can we set up a Zoom invite? Maybe some of those HR communications, View Today articles, things like that. Those I would consider transitory records. They only need to be kept and maintained for as long as you determine they're useful to you and to fulfill the purpose for which they were created. After that time, there is no need to check. You are able to delete those at your own prerogative. What you're not able to delete is records outside of those transitory records. If you are deleting a record that's been created for a business purpose, if you are deleting a student record, if you are deleting a report of any kind, you need to check into that records retention schedule, which will specifically outline the type of record, how you can delete it, whether it needs to be in a shredding box, whether it needs to be double deleted, if you need to contact a third party at the university to come in and delete it, and what the period of time is. So, for example, I will just say, we've talked on who the Office of Primary Responsibility is. If you were to look up student academic and student non-academic misconduct, the Office of Primary Responsibility, once it gets to that investigation stage, as I said, is that academic process. It could be the student conduct office, it could be the secretariat office, or it can be the academic. It will specifically say, we keep the hearing file for, I don't know the specific timeline off the top of my head for each one of those, but I believe one of them is 7 years. We keep it for 7 years from the date of hearing. For my personal office in FOIP, once we complete a FOIP request, we keep it for 5 years from the date that any appeal is concluded. Consent forms. If you were dealing with consent forms, relating back to the question earlier about a student has said that, yes, no, this individual can have access as a third-party consent, that is 12 years. That consent form needs to be maintained for 12 years. How we maintain that is entirely department or unit specific. Some units may keep it in a hard copy in a folder. Some units may choose to scan it into their SharePoint. But irregardless of that, it needs to be kept for that period of time. The reason this is important is that while records are retained, they're accessible under FOIP. If we are required under our records retention schedule to delete a record after 5 years, we have not done so. It's 12 years later and we still have the record. Unfortunately, we missed the boat on that one and we still need to produce it, although it should have been destroyed. It adds liability to the university, it adds cost to the university, it adds storage to the university if individuals are not adhering to those records retention schedule. I just have a few links here that may be worth checking out for those individuals that are specific to the university. The academic misconduct policy and procedure and the misconduct and academic appeals policy have both undergone an update in late 2021. So there may be a few things in there that have changed a little. The privacy policy has not undergone an update, sadly, in a little bit of time, but it's definitely on our list to do. And the code of conduct, I'm sure we're all aware of that. As I said, that brings us to the end. Kind of a Cliff Notes, academic integrity, FOIP intersection 101. If you have any questions, again, my name is Jennifer. I'm the FOIP coordinator. Amanda's our FOIP advisor. You can also reach us at foip@ucalgary.ca. We're part of legal services here at the university, and we are happy to answer any questions. If it's something specific from this course today, something you'd like more information on, or just a general, I'm doing this, is this in line with current practices, processes? We're more than happy to set up those individual training sessions or work with departments or groups on.
Thank you so much, Jennifer and Amanda. I'm just cognizant of the time here and all the participants today. We want to thank you so much for joining us. As we conclude the second webinar of academic integrity, we do have a final session tomorrow entitled One Instructor's Method to Approach Writing a Research Paper Using Enhanced Academic Integrity with Dr. Bronwyn Wheatley. We hope that you're able to join us tomorrow at the same time from 11 till noon. Otherwise, thank you so much, everyone. We wish you a very good rest of the day.